The Fourth Amendment to the United States Constitution serves as a foundational pillar of American jurisprudence, establishing the fundamental right of individuals to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. At its core, this amendment demands that law enforcement officers obtain a warrant supported by probable cause and issued by a neutral magistrate before conducting a search. However, the legal landscape is rarely defined by absolute rules, and the Supreme Court has recognized several carefully delineated exceptions to the warrant requirement. Among these is a specialized and often debated concept known as the single-purpose container doctrine. This doctrine posits that certain containers, by their very outward appearance, so clearly reveal their contents that any expectation of privacy is effectively forfeited. In such instances, the container itself is said to speak to the observer, making its contents as obvious as if they were in plain view. This creates a fascinating intersection between the physical world of objects and the abstract legal concepts of privacy and state power. To understand the depth of this doctrine, one must move beyond a simple definition and examine the intricate legal theories, historical precedents, and procedural nuances that define its application in modern criminal law. The evolution of the single-purpose container doctrine is inextricably linked to the broader history of Fourth Amendment litigation throughout the 20th century. While the amendment was originally conceived to protect the home from the general warrants used by British colonial authorities, the rise of the automobile and the increased mobility of modern society forced the courts to adapt. This led to a series of decisions clarifying where an individual's reasonable expectation of privacy begins and ends when they are outside the domestic sphere. When a person places an item inside an opaque container, such as a suitcase, a cardboard box, or a backpack, they are generally signaling a desire to keep that item private. The law respects this choice, treating the container as an extension of the person's private domain. Yet, the single-purpose container exception serves as a limit to this protection. It suggests that if you choose a container that is synonymous with illegal activity or specific hazardous items, such as a gun case or a specialized kit for drug distribution, you cannot reasonably claim that you are attempting to hide the contents from the world. The legal fiction at play here is that the search of such a container is not really a search in the constitutional sense, because the contents have already been disclosed by the container's own shape or design. To trace the origins of this doctrine, one must look back to the landmark case of Arkansas versus Sanders, decided in 1979. In this matter, the Supreme Court was tasked with determining whether the automobile exception to the warrant requirement extended to a suitcase located inside a vehicle. While the court ultimately ruled that the police should have obtained a warrant to search the suitcase, Justice Lewis Powell included a crucial footnote that would become the bedrock of the single-purpose container doctrine. Footnote 13 of the Sanders opinion observed that some containers, by their very nature, cannot support a reasonable expectation of privacy because their contents can be inferred from their outward appearance. Justice Powell provided specific examples to illustrate this point, such as a kit of burglar tools or a gun case. He reasoned that when an officer encounters a container that is so distinctive, it is as if the container is transparent. Although Arkansas versus Sanders was later partially overruled by California versus Acevedo regarding the search of containers within vehicles, the logic of footnote 13 remained intact, providing a vital tool for law enforcement and a significant point of contention for defense attorneys. The legal definition of the single-purpose container doctrine relies heavily on the distinctive configuration of the object in question. For the exception to apply, the container must be one that is rarely, if ever, used for any purpose other than carrying the specific illegal or regulated item. This is a high bar for the prosecution to meet. It is not enough for an officer to have a hunch about what is inside, nor is it sufficient for the container to be suspicious. The outward appearance must be so revealing that the contents are a foregone conclusion. For example, a black plastic bag might contain many things: trash, laundry, or illicit substances. Because its use is ambiguous, it does not fall under the single-purpose container exception. Conversely, a molded plastic case shaped precisely like a submachine gun is much harder to defend as an object of privacy. In the eyes of the law, the owner of such a case has knowingly exposed the nature of their possession to the public. The doctrine essentially functions as a bridge between the physical reality of the object and the legal standard of probable cause, allowing for an immediate search when the what is as clear as the where. To fully grasp how this doctrine fits into the broader legal framework, it is helpful to contrast it with other standard warrant exceptions. Generally, the police can search without a warrant under several circumstances. The search incident to a lawful arrest, which allows officers to search the area within an arrestee's immediate control for weapons or evidence. The automobile exception, which allows for the search of a vehicle if there is probable cause to believe it contains contraband. And exigent circumstances, where the immediate need to prevent physical harm or the destruction of evidence outweighs the warrant requirement. The single-purpose container doctrine is unique because it is not based on the danger posed by the individual or the mobility of the vehicle, but rather on the diminished expectation of privacy inherent in the object itself. It is a doctrine based on the visual communication of the container. While a search incident to arrest might allow an officer to open a bag to check for a knife, the single-purpose container doctrine would allow them to open it simply because the bag itself announces that it contains a knife, regardless of whether an arrest is even taking place at that moment. This leads us to the critical link between the single-purpose container doctrine and the more commonly known plain view doctrine. Under the plain view doctrine, an officer may seize evidence without a warrant if they are lawfully in a position to view the item, its incriminating character is immediately apparent, and they have a lawful right of access to it. The single-purpose container doctrine is often described as a literal extension of plain view. The logic is that if the container's shape or distinctive markings reveal its contents, those contents are effectively in plain view of the officer. Legal scholars sometimes refer to this as plain touch or plain feel in other contexts, but in the case of containers, it is a matter of visual recognition. If an officer sees a clear plastic baggie containing white powder, the powder is in plain view. If the officer sees a heavy-duty, reinforced steel box with explosives printed on the side in bold red letters, the single-purpose container doctrine suggests that the explosives are just as visible to the law as the powder in the clear bag. The container, in this sense, becomes a transparent window into its own interior. However, the application of this doctrine is far from uniform across the United States, as evidenced by the significant case of U.S. versus Gust. In this case, the Ninth Circuit Court of Appeals dealt with a situation where a defendant was carrying a pre-formed plastic case. While the officers involved believed the case was designed specifically for a shotgun, the court took a more skeptical approach. The Gust decision is pivotal because it clarified that the single-purpose nature of a container must be evaluated from the perspective of an ordinary layperson, not just through the specialized lens of a trained law enforcement officer. The court argued that if a container could reasonably be used for a variety of legal purposes, such as carrying musical instruments, expensive camera equipment, or specialized tools, then it does not lose its Fourth Amendment protection. In Gust, the court found that the case in question was generic enough that its contents were not a foregone conclusion to the average passerby. This case serves as a vital check on the doctrine, preventing it from expanding into a general license for officers to search any suspicious briefcase or equipment trunk. The differing interpretations of U.S. versus Gust highlight a broader split among federal circuit courts regarding the legal interpretation of what constitutes a single-purpose container. Some circuits adopt a more officer-centric view, arguing that the specialized training and experience of a police officer should be taken into account. From this perspective, if an officer recognizes a specific type of duct tape-wrapped bundle as a common method for transporting narcotics, that bundle should be treated as a single-purpose container. These courts argue that the immediately apparent standard should be informed by the reality of criminal investigations. Conversely, other circuits, like the Ninth, emphasize a more objective, layperson standard. They argue that the Fourth Amendment's protections should not fluctuate based on the specific expertise of the officer on the scene. If a common citizen wouldn't know for certain what was inside the container, then the expectation of privacy remains reasonable. This split creates a complex patchwork of legal standards across the country, where the legality of a warrantless search might depend entirely on the geographic location where the interaction occurs. This judicial tension brings us to the practical challenges of defining outward appearance. In the digital and industrial age, packaging has become increasingly specialized. Does a laptop sleeve reveal a laptop? Most would say yes, but carrying a laptop is not illegal. The doctrine is almost exclusively applied to items that are either contraband per se or highly regulated, such as firearms or explosives. The difficulty arises when legal items are transported in containers that are also used for illegal items. A common example involves bricks of material wrapped in opaque plastic and heavy tape. To a narcotics detective, this is a single-purpose container for cocaine. To a construction worker, it might look like a bundle of specialized adhesive or sealant. When courts grapple with these scenarios, they must decide whether the purpose of the container is defined by its most common use, its intended use by the manufacturer, or its most frequent use in the criminal underworld. The lack of a clear, supreme-level resolution on these specifics leaves both police and citizens in a state of legal uncertainty. For individuals concerned with maintaining their privacy rights, understanding the nuances of this doctrine is essential. Practical strategies for protecting privacy often revolve around the choice of containment. Since the doctrine relies on distinctive configuration, using nondescript, multi-purpose containers is the most effective way to ensure that a warrant is required for a search. A cardboard box, a standard duffel bag, or a generic suitcase are all protected because they are used by millions of people to carry mundane, legal items. The legal protection is strongest when the container is opaque, closed, and lacks any external markings that suggest its contents. Furthermore, the concept of nested containers can provide additional layers of legal defense. If an item is placed inside a specialized case, which is then placed inside a generic backpack, the single-purpose nature of the internal case is hidden by the multi-purpose nature of the external bag. In court, a defense attorney would argue that the officer could not have seen the distinctive configuration of the inner case without first conducting an illegal search of the outer bag. From the perspective of legal defense, the strategy often involves challenging the foregone conclusion aspect of the officer's testimony. If an officer claims that a container was a single-purpose gun case, the defense might produce advertisements showing the same case being marketed for power tools or fragile medical equipment. By demonstrating that the container has legitimate legal uses, the defense can argue that the expectation of privacy was reasonable and that the warrantless search was therefore unconstitutional. This type of litigation often turns into a battle of experts, with professional photographers, musicians, and hobbyists testifying about the diverse ways they use specialized hardshell cases. The goal is to move the container out of the narrow, single-purpose category and back into the broad category of effects protected by the Fourth Amendment. In a broader educational sense, the single-purpose container doctrine serves as a masterclass in the balance of competing interests. On one side is the government's interest in efficient law enforcement and the removal of dangerous items from the public sphere. On the other is the individual's interest in being left alone and maintaining a sphere of privacy that the state cannot enter without a very good reason. The doctrine suggests that privacy is not just a legal status, but a behavioral one. If you act in a way that broadcasts your possessions to the world, the law will not pretend you are keeping a secret. However, the courts must remain vigilant to ensure that this doctrine doesn't become a plain view loophole that swallows the warrant requirement entirely. The requirement that the contents be a foregone conclusion is a high bar for a reason. It ensures that the exception remains the exception and not the rule. As we look to the future of legal analysis in this area, new technologies will likely complicate the doctrine even further. For instance, how do thermal imaging or X-ray scanners interact with the idea of a container speaking for itself? If a container is technically opaque but can be easily seen through by modern technology, does it still afford an expectation of privacy? Current jurisprudence generally holds that the use of advanced technology to see inside a container constitutes a search that requires a warrant, as seen in cases like Kilo versus United States. However, the single-purpose container doctrine deals with what is visible to the naked eye. As the design of containers becomes more sophisticated and specialized, think of custom-molded cases for drones, high-end electronics, or specialized medical devices. The list of what constitutes a single-purpose container will continue to shift. In conclusion, the single-purpose container doctrine is a nuanced and vital part of American search and seizure law. It reminds us that the Fourth Amendment does not protect things, but rather people's reasonable expectations of privacy. When those expectations are undermined by the very objects people choose to carry, the protections of the warrant requirement may fall away. From the foundational footnote in Arkansas versus Sanders to the modern refinements in US versus Gust, the doctrine has been shaped by a continuous dialogue between the need for public safety and the sanctity of personal privacy. For the legal practitioner, it is a field of tactical complexity. For the citizen, it is a reminder that the way we package our lives has profound legal consequences. Understanding the single-purpose container doctrine is not just about knowing the law. It is about understanding the visual language of privacy in a crowded and complex world. Whether an object is a tool of a trade or a vessel for contraband, its outward appearance serves as a silent witness in the eyes of the law, a witness that can either shield an individual from state intrusion or provide the very evidence used against them. This intricate dance of visibility and secrecy remains one of the most compelling chapters in the ongoing story of the United States Constitution. The doctrine stands as a testament to the fact that in the eyes of the law, sometimes a box is just a box, but sometimes a box is an open book. Expanding on this, the legal analysis must always return to the fundamental question, what would a reasonable person think? If the answer is that they would know exactly what is inside, then the Fourth Amendment's shield may not be as thick as one might hope. This reality necessitates a careful and deliberate approach to how we transport our most private or most dangerous possessions, ensuring that the containers we choose do not inadvertently waive the rights we hold most dear. By examining the circuit splits and the practical strategies for defense, we see that the law is not a static set of rules, but a living, breathing conflict of interpretations. The single-purpose container doctrine, while seemingly niche, is a microcosm of the entire Fourth Amendment struggle, pitting the officer's split-second observation against the deep-seated constitutional right to be left alone. It is a doctrine of optics, of common sense, and ultimately of the limits of government power in the physical world. Through rigorous study and application of cases like Sanders and Gust, we continue to define the boundaries of that power, ensuring that the right of the people to be secure remains a reality and not just a historical aspiration. In the end, the single-purpose container exception is a reminder that our choices, even the choice of a bag or a box, carry constitutional weight, and that the distinctive configuration of our lives is always subject to the watchful eye of the law. This deep dive into the doctrine provides a comprehensive understanding of why a simple container can become the center of a major Supreme Court battle, and how the smallest details of an object's shape can alter the course of a criminal trial. It is a fascinating, complex, and essential area of legal analysis that continues to evolve with every new case that reaches the courtroom.